hello. Welcome to Legal Talk. It's great to be with you for today's edition of the podcast. My name is James Panichi. I'm a senior editor with MLEX, and I'm coming to you from the LexisNexis offices in Melbourne. And for those unfamiliar with MLEX, well, it's a global LexisNexis media company that provides reporting and analysis of several key policy areas. Here in Australia, the focus of our independent journalism is mainly data privacy and security and competition, what our US colleagues refer to as antitrust. And indeed, today we're looking at an interesting competition story that our Australia team has been covering over the past few years, and that is the future of merger laws. Under the 2010 Competition and Consumer Act, companies planning to be part of a merger or an acquisition can run it past the Australian Competition and Consumer Commission. The regulator then needs to assess whether the deal would harm competition. If it does, well, the ACCC could ask the companies to put forward remedies, or it may even choose to block the transaction altogether. But here's the thing, Australia's merger regime isn't compulsory. Companies aren't obligated to notify the ACCC, although they could then be targeted by legal action further down the track. And this informal voluntary regime places Australia at odds with other significant jurisdictions around the world that have mandatory notification mechanisms. Not surprisingly, the ACCC is concerned that our laws place the agency on the back foot when it needs to weigh up the impact of a deal, in particular when it comes to global transactions where Australia is often overlooked or even deliberately sidestepped. So, what can be done? Well, in a speech last month, ACCC Chair Gina Cascott-Lieb outlined her vision for a new M&A regime. And luckily for us, our Sydney-based senior reporter Laurel Henning has been keeping an eye on this discussion, and she joins me right now. Hi Laurel, how's it going?
All good here, James. How are you?
Yeah, not too bad. Now, let's talk about this big merger law announcement. Why was this such a big deal and where did it come from?
Well, the former chair of the ACCC, Rod Sims, had made a key speech on this in August 2021. So this is something that had been brewing for a while. He'd outlined some initial proposals to overhaul Australia's merger regime, something he'd expressed quite a lot of frustration with in his time at the head of the regulator. So we knew that he really wanted to see a mandatory regime. We also had heard from him calls for digital platform-specific measures where there was a concern of big tech companies acquiring nascent rivals. It's sort of the haunting of the Facebook Instagram deal, if you like. And then what we saw was Sim's successor, Gina Cascott-Lieb, as you mentioned, in April. She had always really been, since taking on that role at the head of the regulator, quite measured in her comments on mergers and expressing occasional frustrations perhaps at Australia being late or the last to be notified on big international global mergers and a lack of information provided to the regulator. And that frustration seems to have led her to this latest announcement and the speech she made to the National Press Club last month, where she outlined the ACCC's new merger law proposals. And in that speech, she confirmed what we'd known for a long time, that what we're going to see is something like a mandatory suspensory regime.
In other words, the idea of overhauling the merger laws had certainly been raised before, had been discussed before, but Gina Cascott-Lieb's speech really solidified what the plan would look like. And of course, this is all up to the Australian government as to whether it pursues these ideas or not. But why did this most recent announcement create some level of consternation, and what were the main takeaways in your view?
I think the headline-grabbing element, even though it had been discussed for a while, is the end to Australia's voluntary regime, even though among OECD countries it is really an outlier in having that voluntary system. But in talking to lawyers and sources, my understanding was really that ship had sailed. So despite it grabbing headlines, we knew that it was coming. And number two, if you were designing a merger system in 2023, you wouldn't design a voluntary one. But more than the change from voluntary to mandatory, I think the main takeaways here are the thresholds, which would dictate how this will work, as well as the broadening of the substantial lessening of competition test and factors that would lessen competition. So at the moment, what that means is at the moment, factors that have to be taken into account when considering whether a transaction would substantially lessen competition, which is really that sort of hard line for a deal, are the current level of competition in a market, the concentration of the relevant market, and the availability of substitutes. Now, among the new factors are the loss of actual or potential competitive rivalry. So then we get to those nascent competitors and that concern that I spoke about briefly earlier, and increased access to or control of data, technology, or other significant assets. Now that really gets into data aggregation of the big tech mergers we've seen in recent years and efforts by the regulator and regulators around the world, we're seeing this around the world, to avoid that moving forward. So those are just two examples of some of the new factors that we might see.
Now, you and I have covered merger appeals and reviews in both the Federal Court of Australia and Australia's Specialised Competition Tribunal, which is a tribunal that deals obviously specifically with competition matters, and it's become a little bit more relevant following recent legislative changes in Australia. So in what venue would these changes ultimately play out, assuming, of course, that the changes are adopted?
I think really there is a role for both the Australian Competition Tribunal and the Federal Court of Australia. But what the ACCC really wants to see is less cases going to the Federal Court of Australia, where we know it's had less success on competition issues, in part because of once you get to the Federal Court, you're arguing over a question of law enforcement. Has someone broken the law, rather than competition law? Is there an issue of competition and how do you prove that? So it's evidence-based and it's a different argument. There are different pressures, different thresholds to meet when you're in the court. Putting the tribunal more at centre stage than it has been perhaps previously moves more in the direction of the ACCC being the first point of making a decision. So I think it really lends itself to how the ACCC wants to see these decisions play out. This is also where we'll see the public benefits test stick around and play a role. So if companies don't get clearance on competition grounds, they can apply for clearance based on public benefits. But the goal here is that most transactions are decided on competition grounds. And the ACCC has said that the Australian Competition Tribunal is the appropriate review body for ACCC decisions in the formal regime. And the federal court sort of has this role of considering applications for declaration and judicial review.
And we should just open a quick parenthesis. So there are two systems of merger clearance. One is the informal mechanism, which we've been talking about extensively. The other one is the more formalised authorisation process, in which as you mentioned now, you can argue that there is a public benefit. So the public benefits outweigh any substantial lessening of competition as a result of the deal. And then if that is in fact considered to be the case, so if the public benefits are seen to be outweighing the substantial lessening of competition, then it's allowed to go ahead. And I must say that some of the competition lawyers that we have spoken to have been trying to read between the lines of Cass Gottlieb's speech on that front, because they're wondering whether there might be changes on the horizon. So public benefits may still be considered, but with a slightly different emphasis when held up against the competition consideration. There's also the point that they make that not many authorisation requests under current rules, that not many authorisation requests actually end up proceeding on the basis of public benefit tests. So often they rely purely on competition matters. It's seen to be not a particular concern in terms of competition, so the public benefits aren't even considered. So that raises the question of how valuable a tool is this? And I mean, obviously that's debatable, and that's a conversation that we'll continue to have over coming months, and possibly something that will be a part of any possible future legislative changes. That will be certainly a key point for us to follow.
Absolutely. And I think the fact that the public benefits test wasn't included in Sims's initial discussions in August 2021, but reappeared in April 2023, really shows that more conversation, more consultation had been had between those 2 points. And the public benefits test does have a role to play. And I think some people were really concerned about it being removed, especially when we're now seeing a lot of people make decisions on environmental grounds or arguments that might be a benefit as part of a deal. Now you can get into discussions about greenwashing in that area as well, whether companies are really being realistic about those potential environmental benefits. But the public benefit test, I think, does have a really important role to play. I think at the moment, there will be lots of different steps before you get to the public benefit test under what's being proposed at the moment, rather than what we have today in today's system is that Companies have, yes, these two sorts of routes that they can take. They either go the informal public route or they go the formal notification route where that public benefit test is there from the get-go. And that's not how this will probably look.
Okay, let's take a few steps back here because, of course, a call for change implies that there might be problems with the current system. But as we look forward, as we move ahead with this proposal, what are the main points of uncertainty in your view?
Well, of course, we've got to wait for government to decide what to do. As you said at the top, James, this is all in the hands of government. We haven't even seen any actual proposals that the ACCC has put forward. All we have at the moment is the speech that Gina Cass-Gottlieb made to the National Press Club in April. Aside from the uncertainty of just how many reviews this could cause in terms of merger reviews and how the ACCC will even cope with that influx of deals that maybe they don't review at the moment, and the potential delays that could cause for transactions, from contacts that I've spoken to, the main questions are, what are the timelines here? What is the risk of delay to a transaction, considering that each stage under discussion at the moment could have a few hurdles? Or you could get called in. So if you don't meet a threshold for automatic review, the regulator can still call your deal in for review. What exactly are the thresholds? What is material for entrenching market power materially or materially extending a position of substantial market power? That's going to be different for every market. So there's still so much here that we don't know.
Laurel, you have met and surpassed the LN podcast threshold today, in my view. It's always great fun chatting about Australian competition matters. We should do it again very soon.
Thanks, James.
Laurel Henning is an MLEX senior reporter, and she was speaking to me from the LexisNexis offices in Sydney. And of course, you can read the very best of MLEX's global reporting and analysis at our website, mlexmarketinsight.com. That's mlexmarketinsight.com. Just click on the News Hub tab. And that's it for today's edition of the Legal Talk series. From me, James Panichi, and everyone here at MLEX and LexisNexis, thank you for your company. I hope to see you again very soon. Bye for now.